in Guyana, in Limpopo, where over 50 villages are without clean water, running water, despite government spending of 2.3 billion on a bulk water supply project that started in 2013. Is incomplete and yet to yield results.
Thank you very much, Motebula. Any further notices of motions so that we can move on to motions without notice? Thank you very much. We'll then move on to motions without notice. We'll start with Tim. Honorable Tim.
Thank you, Chair. On behalf of the Democratic Alliance, I hereby move without notice that this House notes with great concern the worsening water crisis throughout the entire Ugu District municipality, which has plagued over 200,000 residents across 4 municipalities, the majority of which are poor, elderly, and vulnerable. Notes that economic activities in the district, including industry, agriculture, and tourism, have been severely affected, leading to over 30,000 direct or indirect job losses over the last 2 years. Notes that the health services at the St. Andrews, Murchison, and Port Shepstone regional hospitals have been severely curtailed, leading to delays in surgeries, inadequate hygiene facilities, and even a lack of water for patients to drink. Notes that the recently released Salak report exposed massive corruption relating to water and sanitation contracts. Indeed, the municipal manager, Didi Nadu, has been suspended due to his alleged corrupt involvement and personally benefiting from tender awarding. Notes that the district municipality has presided over the complete collapse of the billing system, which has reduced the revenue stream to a mere trickle. Notes the numerous incidents of sabotage of vital water infrastructure. Despite cases being opened with the South African Police Service, there has been no progress on investigations and 0 arrests. Calls on the Minister of Police to immediately deploy a team of experienced investigators and crime intelligence officers to assist with the prevention, arrest, and conviction of those involved in municipal infrastructure sabotage. Calls on the Minister of Cocta to immediately place the water management system in Ray Nkondani municipality under the control of the Mgani Water Board. Calls on the Minister of Cocta to immediately place the Ugu District Municipality under Section 139(5)A administration to restore the financial situation and restore a functional water system. I so move. Thank you, Chair.
Thank you very much. Any objection? There being no objection, the motion is agreed to in terms of Section 65 of the Constitution. Honorable Nana.
Thank you, Chairperson. On behalf of the Democratic Alliance, I hereby move a motion without notice that this Council condemns in the strongest possible terms the callous killing of Ms. Nomzamo Dugwana and her 5 children aged between 6 months and 10 years in Kwaiman village just outside Mkanduli in the Eastern Cape. That this Council notes that these barbaric murders occurred whilst our country is observing 16 days of activism against gender-based violence. That this Council condemns that this Council commends the South African Police Service for apprehending the suspect who is believed to have been trying to flee the country. That this Council calls on the NPA, the National Prosecuting Authority, to leave no stone unturned in preparing a watertight case against the accused, and that this Council sends condolences to Nomzamo's mother, Mrs. Nolungile Dugwana, her family and friends during these difficult times. I so move.
Thank you very much, Honorable Nana. Any objections? There being no objections, the motion is therefore agreed to in terms of Section 65 of the Constitution. Honorable Lutuli.
Ngibonge Chairperson. Ngisukuma egameni Economic Freedom Fighters ngenza lesiphakamiso. Ngiphakamisa ukuthi le ndlu iqaphele ukwanda kwezenzo zobugebengu edolobheni laseVerulam lapho kwenzeka khona izigameko ezicishe zibe yisihlanu ngosuku emini kaBha. Siqaphele ukuthi iningi lalamacala legcina lingabikwanga emaphoyiseni ngenxa yokuba abantu bamanqikanqika ukuvula amacala. Kusobala ukuthi abezomthetho bakuleli dolobha bayahluleka ukulwisana nobugebengu okukhombisa ngokusobala ukuthi abantu bakithi abaphephile emphakathini. Lokuhluleka kwabomthetho ukwenza umsebenzi laphaya edolobheni laseVerulam kuyinto engamukelekile. Sithi ungqongqoshe wamaphoyisa uMnumzane uBhekicele akalisukumele phezulu lolu daba alubhekisise. Ngiphakamisa kanje, ngiyabonga.
Thank you very much, Honorable Truly. Any objections? There being no objection, the motion is agreed to in terms of Section 65 of the Constitution. Honorable Bebe, Bibi.
Okay, thank you very much, Chairperson. I here move on behalf of the ANC that the council notes that 3 children have died due to illegal electricity connection in Jigajo settlement in Pietermaritzburg, and that the council further notes that the tragic incident took place when the country commenced with the 16 days of activism against women and children. Also that the council therefore call on COGTA in KZN to leave no stone unturned to find those responsible for the tragedy. I so move, Chairperson.
Thank you very much, Honorable Bibi. Any objection? There being no objection, the motion is agreed to in terms of Section 65 of the Constitution. Honorable Faisal.
I've got a motion without notice, Chair.
Yes, that's what we're doing now.
Thank you. On behalf of the Democratic Alliance, I hereby move a motion without notice that this Council notes that an ever-increasing number of municipalities are under administration in terms of Section 139(1)(b) of the Constitution for the second time since 2018. Since the first intervention in Butterworth in 1998, several others followed over the years, regressing into a disaster, and little evidence could be found of improved financial conduct with any of these municipalities. Further notes that the various interventions failed to yield clean audits, reduce ESCOM debt, or improve service delivery, which begs the question as to why the provincial government saw it. Sorry, Chair, we remotely today. While the provincial governments saw it to continue down this ineffective trajectory without considering the regional governments created an environment nurturing unaccountability without consequences, and within the environment allowed fraud and corruption administrations to develop. Further notes that even the constitutional preventative measures of Section 139(1)(b) and or (c) were misused to settle political scores instead of governing towards respectfully upholding the Constitution and the laws in compliance with their mandates. Lastly, takes note that the current destructive course will have direct consequences for the economy and the communities entitled to basic services. I so move. Thank you.
Thank you very much. Any objection? No objection. There being no objection.
Chairperson.
Okay. There being an objection, the motion may not proceed with this, as all members know.
Objection, Chairperson.
It will not become a notice of motion. Honorable Gillian.
Chairperson, I rise on behalf of the African National Congress that this House notes more than 40,000 pupils have allegedly still not been able to register for next year in Gauteng. This could cause anxiety and create chaos in our communities. Therefore, call upon MEC Panyaza Lesufi to attend to this matter urgently, working together with the Department of Education and ensure speedy resolutions to avoid a crisis. I so move.
Thank you very much, Honorable Gillian. Any objection to the motion? None. And there being no objection, the motion is agreed to in terms of Section 65 of the Constitution. Honorable members, thank you very much. We'll now proceed to the first order.
Honorable Chairperson, sorry, on a point of order. Honorable Chairperson, on a point of order.
Yeah.
My hand has been raised since the beginning for a motion without notice, and I have not been recognized. It's Honorable Okamp.
Okamp.
Yes.
Didn't we start with you?
No, we did not. But we can finish with me if you don't mind, Honorable
Chairperson. Okay, let's finish with you.
Thank you so much. Thank you, Honorable Chairperson. Honorable Chairperson, on behalf of the Democratic Alliance, I hereby move a motion without notice that this Council notes that during the deliberation of the provincial mandates for the Division of Revenue Bill, several provinces asked for more money to be made available in order to assist the agricultural sector that are suffering under the effects of the crippling drought. Further notes that Treasury, in its answers to the provinces, said that more money can be made available to provinces should a state of disaster with regards to the drought be declared either nationally or provincially. Also notes that during February this year, the country was declared as a drought disaster area and that the disaster declaration was not renewed and therefore are not in place anymore. Further notes that many parts of our country has since February this year still not received yearly average rainfall and are still experiencing the devastating effects of this prolonged drought, and that there are areas that received average rainfall but due to the devastating effect of this drought still do not have enough grazing available for the animals. Lastly, notes that should certain provinces or areas within provinces be declared as drought disaster areas, provinces will have more access to funding in order to assist the agricultural sector in those areas in the provinces that are still suffering due to this drought, and that this House requests the Minister of COCTA and all the President and all the relevant provincial premiers to investigate the possibility of declaring certain areas as drought disaster areas as a matter of urgency. I so move. Thank you.
Thank you very much. Any objection?
Objection, Chair.
And where is the objection coming from?
Ndongeni.
There being an objection, the motion may not be proceeded with. It will become a notice of a motion. We'll now proceed to the first order on the order paper. First order, local government, municipal structures amendment bill, and report of select committee on cooperative governance and traditional affairs, water and sanitation, and human settlement thereon. So I'll call on the first speaker, Honorable TSC Dodo.
Thank you very much, Honorable Chairperson of the National Council of Provinces, Honorable Masondo, and honorable members to this plenary session. As we glide towards a full cycle of our program towards our recess amid the resurgence of the COVID-19 pandemic, we acknowledge with great enthusiasm our collective efforts to examine and propose the passing of the two legislation applicable in local government sphere that we are considering today. The first one, the Local Government Municipal Structures Amendment Bill, is vital and central to the government's efforts to bring about a new paradigm shift in our service delivery and development value chain. This bill is a necessary intervention to improve and enhance local government resilience and sustainability in the delivery of services to complement the work of a developmental state. The envisaged amendments to the Structures Act indeed resonate with the challenge towards the smooth implementation of the district development model. If these are successfully and correctly implemented, they will collectively improve integrated planning for cooperative governance towards a new integrated district-based service delivery approach aimed at fast-tracking service delivery, ensuring that all our municipalities are adequately supported and resourced to carry out their mandates. Honorable Chair, the current development ethos indeed further require a structural review of local government legislation and regulatory framework to sharpen the ability of the state through the third sphere of government to maximize a fundamental shift towards accelerated service delivery. Once passed into law, this municipal structures bill will ensure the following. It will provide for a minimum of 10 councillors per municipality. It will provide for the prohibition of a councillor who's found guilty of a breach of the Code of Conduct for councillors for a period of 2 years. It will provide additional functions of the Speaker in order to improve maintenance of order and adherence to the Code of Conduct of councillors. In addition, the new amendments will provide for a whip of a council, clarify the formula for the composition of an executive committee, remove all references to district management areas, and to remove all references to plenary executive system as a type of municipality. Honorable Chair, other than that, the new legislation will clarify the date of assumption of office by a councillor, allow for an extension on the declaration of results of an election, and requires the municipal manager to inform the MEC for local government in the province, in addition to the Independent Electoral Commission, of vacancies in the wards. It is vital to support this legislation because it will provide for the MEC of local government in the province to call and set the date for by-elections and allow the MEC to designate a person to call and chair a meeting of a municipal council when a speaker, an acting speaker, or municipal manager refuses to call the meeting. This is a widespread problem that needs attention. Honorable Chair, the proposed amendments also provide for the establishment of municipal public accounts committees in order to strengthen oversight and accountability, especially with regard to financial and performance management. Lastly, the proposed amendments to the Municipal Structures Act will provide for the resolution of a situation where excessive seats may arise from the seat allocation in local municipalities, amend the time frame for the municipal manager to inform the chief electoral officer of vacancies when they arise, empower the MEC for local government in a province to inform the chief electoral officer of the IEC of vacancies if the municipal manager fails to do so. Equally important, the amendments will clarify the supplementation of party lists for local municipalities, provide for the resolution of municipal multiple seats, which may arise where a candidate qualifies for elections to more than one seat, clarify the supplementation of party lists for district municipalities, and provide for the transitional arrangements in respect of municipalities with plenary executive system. Honorable Chair, The public participation processes in all provinces have been followed on the Municipal Structures Amendment Bill in conformity with the systems, procedures, and timelines, including extensions where necessary to enable receipt of all negotiating mandates from the 9 provinces. As such, all provinces submitted details of their respective public participation processes to this bill. This includes the submission of lists of the individuals, number of public hearings, names of organizations, as well as stakeholders consulted across our provinces. The National Department of Cooperative Governance was central and instrumental in all the briefing arrangements across provinces, including the responses to negotiating mandates and amendments to the bill. This bill was duly adopted by the Select Committee to the extent of confirmation of final mandate. Therefore, Honorable Chair, this bill is in terms of Section 76 of the Constitution, classified as Section 76 bill, as it affects provincial interests. Finally, Honorable Chair, on behalf of the Select Committee, I move for the adoption and approval of the Municipal Structures Amendment Bill by the National Council of Provinces and its eventual passage into law. Thank you very much.
Thank you, Honorable Dodovu. That concludes the debate. We shall now proceed to voting on the bill, and I shall allow provinces the opportunity to make their declarations of vote in terms of Rule 71, if they so wish. Maximum time for declaration, is 3 minutes per declaration. Any province wishing to make a declaration, any province wishing to make a declaration? None. We will now proceed to voting on the question, and the question is that the bill be agreed to, and when called upon to do so, heads of delegations must indicate whether they vote in favor, against, or abstain. We'll start with the Eastern Cape. Eastern Cape?
Eastern Cape, Yesega.
Eastern Cape, Yesega. Free State?
Free State is in support, Honorable Chair.
Free State in support. Gauteng?
Gauteng
is in support, Honorable Chair.
Gauteng in support. KwaZulu-Natal?
KwaZulu Natal iyayixhasa sihlalo.
KwaZulu-Natal iyayixhasa. Limpopo?
Limpopo supports.
Limpopo support. Mpumalanga?
Mpumalanga support.
Mpumalanga supports. Northern Cape?
Northern Cape support, Honorable Chair.
Northern Cape supports. Northwest?
Northwest support, Chair.
Northwest support. Western Cape?
Western Cape support.
Western Cape supports. So all provinces have voted in favor. I therefore declare the bill agreed to in terms of Section 65 of the Constitution. We will now proceed to the second order on the order paper. Customary initiation bill and report of Select Committee on Cooperative Governance and Traditional Affairs, Water and Sanitation, and Human Settlement thereon. I now call on Honorable T.S.C. Dodovu, Chairperson of the Select Committee, to present the committee report. Honorable Dodovu.
Thanks once more, Honorable Chair and fellow members of Parliament. The customary initiation in South Africa is an important cultural practice spanning many centuries. It is differently practice by many communities as a sacred and respected practice. Therefore, this bill, the Customary Initiation Bill, heralds a new epoch in terms of this practice and marks the beginning of regulating it in terms of the Constitution and all the applicable laws of the Republic. To many communities, this practice is an integral part of their lives because it marks the transformation of young initiates to adulthood and prepares them to be responsible in their societies. Honorable Chair and members, we all know the devastations and effects of customary initiation in many parts of our country. This has not only resulted in the loss of lives of many young boys and girls, but also deprived us of future leaders. As the society, we cannot sit back in helpless surrender, fold our arms and keep quiet when all this is happening. Accordingly, the Customary Initiation Bill is a necessary intervention and is a product of a responsible government towards its people to avoid loss of life and serious injuries caused by illegal initiation and other related causes. We note that in some cases, the customary practice of initiation has been subject to abuse. Even some initiation schools operate for personal financial gain, only with little or no concern for the well-being of initiates. Honorable Chair, it is the right of each initiate to health and education, good quality health care and counseling. They also have the right to adequate supervision by an adult or caregiver they trust. It is also important to have approved traditional surgeons and healthcare practitioners to perform initiation practices with clean, hygienic equipment and in environments that are acceptable. Therefore, Honorable Chairperson, the Customary Initiation Bill seeks to provide for the effective regulation of customary initiation practices and for the establishment of a National Initiation Oversight Committee and the Provincial Initiating Coordinating Committees and their related functions. This bill seeks to provide for the responsibilities, roles and functions of the various role players involved in initiation practices and their governance aspects. In addition to this, the Customary Initiation Bill provides for the effective regulation of initiation schools, for the regulations of powers of the Minister of Traditional Affairs and the premiers of different provinces to ensure that this is successful. In respect of this bill, there are foreseeable financial implications, and this entails traveling costs for members of the established committees during the initiation seasons, as well as costs associated with awareness campaigns necessary at national and provincial levels. Therefore, in this context, Honorable Chair, the public participation processes in all provinces have been followed on the Customary Initiation Bill in order to conform with the systems, the procedures, and the timelines, including the extensions where it was necessary, in order to enable the receipt of all negotiating mandates from different provinces. As such, Honorable Chair, provinces submitted all details of their respective public participation processes to them on the bill. This includes the submission of lists of the individuals, the number of public hearings held in provinces, the names of organizations and institutions which were consulted, and all the relevant stakeholders. Honorable Chair, the Department of Traditional Affairs played a central and pivotal role in all the briefings that ensued across the provinces. And this includes the speedy responses to negotiating mandates by provinces and the amendments to the Customary Initiation Bill. This bill was therefore adopted by the Select Committee on COCTA, Human Settlements, Water and Sanitation, to the extent of confirmation of final mandates from different provinces. Therefore, this bill, Honorable Chair, is in terms of Section 76 of the Constitution and accordingly classified as Section 76 bill as it affects provincial interests as well. Having said that, Honorable Chair, on behalf of the committee, the Select Committee on COCTA Human Settlements, Water and Sanitation, I'm on the move that this report be adopted and approved on the Customary Initiation Bill by the plenary of the National Council of Provinces and its eventual passage into law. I thank you.
Thank you very much, Honorable Dodogu. That concludes the debate. We shall now proceed to voting on the bill. But before we do so, I'll allow provinces the opportunity to make their declarations of vote in terms of Rule 71, if they so wish. Just a reminder, maximum 3 minutes per declaration. Any province wishing to make a declaration? None. We'll therefore have to proceed to voting on the question. And the question is that the bill be agreed to. And when called upon to do so, heads of delegation must indicate whether they vote in favor, against, or abstain. We'll do so in alphabetical order, starting with the Eastern Cape. Eastern Cape?
Eastern Cape, Xhosa.
Eastern Cape, Xhosa, Free State.
Free State votes in favor, Honorable Chairperson.
Free State votes in favor. Gauteng?
Gauteng in favor, Chairperson.
Gauteng votes in favor. KwaZulu-Natal?
KwaZulu-Natal iyayiseka sihlalo.
KwaZulu-Natal iyayiseka. Limpopo?
Limpopo supports.
Limpopo supports. Mpumalanga?
Impumalanga yayemukela sihlalo.
Mpumalanga yayemukela. Northern Cape?
Northern Cape supports, Chair.
Northern Cape supports. Northwest?
Northwest yayamukela ndula situlo.
Northwest yayemukela. Western Cape?
Western Cape supports.
Western Cape supports. Voting is now closed, and the majority of the, if we move on to determining the result, all provinces have voted in favor. I therefore declare the bill agreed to in terms of Section 65 of the Constitution. We'll move on to the third order on the order paper. The third order is Traditional Courts Bill and report of Select Committee on Security and Justice thereon. I now call on Honorable Shaik, Chairperson of the Select Committee, to present the committee report. Honorable Shaik.
Thank you, Honorable Chairperson, and good morning, honorable members. Honorable Chairperson, the Traditional Courts Bill was referred to the Select Committee on Security and Justice on the 31st of October 2019, after being revived in the Council on the 17th of October. The committee has agreed to the bill with amendments. Honorable Chair, traditional courts exist, and it is constitutionally essential that they be transformed to align them with the new constitutional dispensation. Chapter 12 of the Constitution recognizes the institution, status, and role of traditional leadership according to customary law, subject to the Constitution. And Schedule 6 of the Constitution recognizes the existence of traditional courts. Currently, traditional courts are still governed by sections 11 and 20 of the Black Administration Act 38 of 1957. However, in this bill, these sections of the Black Administration Act are repealed. The objectives of the bill, as contained in Clause 2, is to create a uniform legislative framework regulating the roles and functions of traditional courts in the resolution of certain disputes and in accordance with constitutional imperatives and values. The bill is intended to improve access to justice services by enhancing the effectiveness, efficiency, and integrity of traditional courts for the purposes of resolving disputes with a view to promoting social cohesion, coexistence, and peace and harmony. The bill affirms the role of traditional courts in terms of customary law and facilitates the full and meaningful participation without discriminating against any member of a community in a traditional court in order to create an enabling environment which promotes the rights enshrined in Chapter 2 of the Constitution. Honorable Chairperson, traditional courts are accessible to anyone who wants to use them. However, this should be understood in the context of Section 30 and Section 31 of the Constitution. Section 30 provides that everybody has the right to use the language and participate in the cultural life of their choice. Section 31 affords persons the right to belong to a cultural, religious, or linguistic community, to enjoy their culture, practice religion, and the use of their language, and to form, join, and maintain cultural, religious, or linguistic associations and other organs of civil society. These rights must be exercised in a manner that is not inconsistent with the Bill of Rights, and these sections already give persons a choice in practicing their culture and does not impose a duty on them. Clause 3 of the bill sets out the guiding principles which must be borne in mind when implementing the bill so as to embrace the values enshrined in the Constitution. In terms of Clause 2b, when dealing with disputes, the courts must be mindful of the existence of systemic unfair discrimination and inequalities or attitudes which are in conflict with the Constitution, or which have the susceptibility of excluding meaningful participation in traditional court proceedings by any person or groups of persons, particularly in respect of gender, gender identity, sexual orientation, age, disability, religion, language, marital status, and race, brought about by colonialism, apartheid, and patriarchy. Furthermore, Clause 3, Subclause 2e states that a founding value on which customary law is premised is that its application is accessible to those who voluntarily subject themselves to that set of laws and customs. This provision therefore emphasizes the voluntary nature of the traditional court system. Clause 4 deals with the institution of proceedings in traditional courts. Proceedings may not be instituted if the dispute in question is being dealt with at another level within the traditional justice system, or if the matter is pending or has been finalized by a court in the judicial system, or is being investigated by the South African Police Services. This clause, read with Schedule 2, sets out the types of disputes which traditional courts are competent to deal with, which are less serious disputes which disturb harmonious relationships within communities. Honorable Chair, with regard to gender representativity and vulnerable groups, the bill includes provisions that seek to promote the right of equality within traditional courts. Traditional courts must be made up of women and men pursuant to promoting the right to equality as contemplated in Section 9 of the Constitution. Traditional courts are required to promote and protect the representation and participation of women as parties and members of the courts, and the Minister and the Commission for Gender Equality are required to put measures in place to promote gender equality in these courts and to report annually on these to Parliament. Further safeguards are contained in the bill for the protection and assistance of vulnerable groups. The bill requires, for instance, that all court proceedings must be open to all members of the community at a place which is accessible to members of the community. Proceedings must be conducted in the presence of both parties, and both parties must be able to participate fully in the proceedings without discrimination on any of the prohibited grounds referred to in Section 9, subsection 3, the right to equality of the Constitution. Failure to comply with these important procedural aspects can result in the matter being taken on review to the High Court. Provincial registrars are required to assist unhappy litigants to take their matters on review. Parties in proceedings before a traditional court are furthermore allowed to be assisted by any person of their choice in whom they have confidence, although legal representation is not allowed. Furthermore, if a party is aggrieved by the decision or order of a traditional court, they may, after exhausting all the traditional court system appeal procedures, refer that decision or order to the magistrate's court to hear the matter and take a decision. Honorable Chair, Clause 5 deals with the composition of and participation in traditional courts, and Clause 7 deals with the procedure in traditional courts. Clause 6 sets out the nature of the traditional courts and emphasizes that traditional courts are courts of law, the specific purpose of which is to promote the equitable and fair resolution of disputes in a manner that is underpinned by the value system applicable in customary law and custom, and function in terms of the Constitution. Their main emphasis is on preventing conflict, maintaining harmony, and resolving disputes in a manner that promotes restorative justice, social cohesion, and reconciliation. Clause 8 sets out orders that the traditional court may make. The type of orders provided for in this clause is restorative in nature. For instance, compensation and redress, which are aimed at restoring relations between parties and promoting harmony. Clause 9 provides for the enforcement of orders made by traditional courts. However, if an order of a traditional court is not complied with, the party in whose favor it is made may escalate the matter to the clerk of the traditional court, who must try and resolve the matter or refer the matter to a justice of the peace appointed by the minister for that purpose, in terms of the Justices of the Peace and Commissioner of Oaths Act. Clause 10 provides for the appointment or designation of provincial traditional court registrars and sets out their role and responsibilities. Clause 11 allows for the review of procedural shortcomings in the High Court, as I've already indicated. Clause 12 deals with referral of matters from traditional courts to magistrates' courts if a party is aggrieved by a decision or order of a traditional court. Clause 13 and 14 deals with the record of proceedings of traditional courts and the transfer of disputes from traditional courts to magistrates' courts and vice versa. Clause 15 deals with the limitation of liability of members of traditional courts for anything done in good faith, while Clause 16 deals with the code of good conduct and the enforcement thereof. Clause 17 empowers the cabinet member responsible for the administration of justice to make regulations on various matters required under the law, including regulations on the training of traditional leaders and members of traditional courts and the involvement of paralegals. Clause 18 deals with the transitional provisions. Among others, this clause repeals all existing former homeland legislation regulating traditional courts, and Clause 19 contains the short title and commencement. Schedule 1 deals with discriminatory behavior, which is prohibited on various grounds, and Schedule 2 deals with the matters which a traditional court may hear and clearly specify these matters. Honorable Chair, in terms of financial implications, the department subjected the bill to a costing exercise and undertook to use existing resources as far as possible in the implementation of this bill. The main financial implications for the state would be in the form of personnel and goods and services relating to the provincial registrars and their support staff, as well as training. The department envisages that the provincial registrars would be officials at the level of director. Honorable Chair, in terms of the committee process, the Department of Justice and Constitutional Development briefed the committee on the 9th of October 2020. 2019, provincial legislatures conducted their public participation process between November 2019 and February 2020. The committee received 8 negotiating mandates in favor of the bill, with 1 province not supporting the bill. On the 21st of October 2020, the committee met to consider negotiating mandates, the responses of the Department of Justice and Constitutional Development to the negotiating mandates, and matters raised by the Parliamentary Legal Advisor. Some of the pertinent points raised in discussion included that the bill does not seek to establish traditional courts, nor change customary law, but rather align the functioning of traditional courts with the Constitution. Many provinces raised the concern that legal representation was not allowed in traditional courts. However, the traditional court system is not punitive, but it's based on restorative justice. and the need for legal representation is unsuited for dispute resolution in the context of the traditional justice system. Now, although the opt-out clause was removed from the bill by the Portfolio Committee, it is clear in Section 30 and 31 of the Bill of Rights in the Constitution that involvement in cultural life is a voluntary exercise. However, in Clause 3, related to the guiding principles, Clause 4, institution of proceedings in traditional courts, as well as Clause 6, the nature of courts, the bill still provides for persons to execute their right not to participate. With regard to women and vulnerable groups, regulations that will be developed for the bill that will be developed after the bill is finalized would contain mechanisms to ensure the promotion and participation of women and vulnerable groups. In addition, training offered would sensitize officials of the court, as well as presiding officers, to the protection of rights for vulnerable groups. The involvement of paralegal interns in the functioning of the court would also be an inbuilt safeguard, even if it is not statutorily imposed. In addition, in broader terms, the provisions of the bill read together, namely clauses 7, clauses 10, subclause 2b, clause 11, clause 12, subclause 1, and clause 17, subclause 1m, prevent a form of protection and mechanisms to address issues that could be faced by vulnerable groups. In addition, the Commission for Gender Equality is well placed to monitor gender representativity and gender equity in the traditional courts, as this is part of their mandate. The committee adopted the series of amendments on the 3rd of November 2020. The committee amended 6 clauses in the bill as follows. Clause 1, in relation to the definition of traditional court, we removed reference to the Traditional Leadership and Governance Framework Act and substituted applicable legislation providing for such recognition so as to accommodate the Traditional and Cohesion Leadership Act. This amendment was also effected in Clause 6 to ensure consistency within the bill. In Clause 6, nature of traditional courts, and another amendment in terms of the level of a principal traditional leaders court was added to the levels of traditional courts in subclause 3. During the course of the committee's deliberations, we noted an error in Clause 11 of the bill, and an amendment was made to ensure that the bill was aligned correctly. With regard to Clause 16, Code of Conduct and enforcement thereof, to ensure that the minister acted after consultation with the relevant cabinet minister, an amendment was made, but also in respect of Clause 16, Clause 5a, the clause was amended so that if there were any transgressions to the Code of Conduct by persons who have a role in terms of customary law for the effective functioning of traditional courts, the relevant provincial MEC would be better placed than the House of Traditional Leaders to deal with transgressions. Clause 18 was amended to stipulate clearly that the repeal of sections 12 and 20 of the Black Administration Act, and finally, Clause 19, the short title of the Act is amended to reflect the year of the bill as 2020 instead of 2019. Honorable Chairperson, the Select Committee met on the 18th of November to consider the final mandates. 7 provinces were in favor, in support of the bill, and 2 were not. The committee was of the view that the bill will go a long way in ensuring the regulation and uniformity of operations of the traditional courts. In addition, gender representativity and gender equity was sufficiently addressed in the various clauses of the bill, and that the Commission for Gender Equality reporting to Parliament was a progressive step to ensuring that Parliament strengthens its oversight over the functioning of traditional courts. The committee was further assured by the department that the drafting of regulations would occur speedily, as the regulations will give meaning and effect to the provisions of the bill and further ensure the effective functioning of these courts. The committee encourages the department to ensure that training occurs in all provinces on the implementation of the bill to all those who may utilize the traditional court system. Honorable Chair, the Select Committee on Security and Justice, having considered the Traditional Courts Bill B1B 2017, referred to it on the 31st of October and classified by the JTM as Section 76 Bill, submits an amended bill, namely the Traditional Courts Bill B1D 2017, for the Council's consideration.
As you conclude, Honorable Member.
Yeah, I thank you, Chairperson. I'm done.
Okay,
thank you very much.
Thank you very much. That concludes the debate. We shall now proceed to voting on the bill. But before we do so, I shall allow provinces the opportunity to make their declarations of vote in terms of Rule 71, if they so wish. Just a reminder, maximum 3 minutes per declaration. Any province wishing to make a declaration?
Yes, Chairperson.
Yes, Western Cape, Labuschagne.
Honourable Chairperson, our objections to this bill are simple. It is rooted in the patriarchal system of traditional tribunals, which the ANC seeks to protect. The traditional court system should be a voluntary system aimed at enabling dispute resolution amongst those South Africans who choose to live according to these traditions, customs, and practices. In the National Assembly, the ANC refused to include an opt-out provision, and surely under such circumstances, this bill cannot pass constitutional muster. Furthermore, the bill also makes no provision for legal representation if a person before such a traditional court so chooses, especially in criminal matters. And thirdly, this bill elevates the status of traditional courts to that of courts, rather than it being tribunals as it was originally envisaged. Any province that supports equal rights for women and children, and any province who champions our constitutional principles and the rule of law cannot reasonably support this bill. The Western Cape, therefore, will vote against it.
Thank you very much. Any other declaration? Any province wishing to make a declaration?
Yes, Chair.
Please proceed. Any province wishing to make a declaration?
Yes, Chairperson, President.
Which province is that? KwaZulu-Natal.
Yes, Honorable Chairperson.
Please proceed.
Honorable Chairperson, we do wish to make a presentation on the bill. The one matter that would like to raise the Honorable Chairperson and Honorable members is that we are very concerned about the bill, Honorable Chairperson, in that we live in a constitutional democracy, Honorable Chairperson, where we do believe that we should be synchronizing our country in terms of ensuring that all our people are enjoined in one constitution. Honorable Chairperson, it is our belief that many of our people in all the areas, particularly as you would have seen that a number of areas that would have been sometimes would have been rural areas, you'd find that they are now semi-urban areas, and you have already conflicts whereby there are now assertions that those people need to be subjected to which bill. Do they need to be subjected to the traditional courts bill, or do they need to be subjected to the other laws of the country? The other issue that we are concerned about, Honorable Chairperson, is the issue of the cost related to this bill. Honorable Chairperson and honorable members, you are all witnesses to the fact that as we sit in KwaZulu-Natal, we are sitting with the dispute that arose as a result of the payment of Izinduna, whereby that bill was not costed, arising as a result of that, with a bill of more than billion, which was even to date have not been clarified, which was supposed to be a back pay for Izinduna in KwaZulu-Natal. Honorable Chairperson, this bill talks about justices of peace, talks about the clerks, talks about the personal staff and other support staff that are supposed to be dealing with this bill. As we talk, Honorable Chairperson, we have been told by the Minister of Finance that we need to cut on the cost of the staff, and we need to ensure that all the departments have frozen the employment of the staff, and our budgets have been cut. Now you've got to appoint the presiding officers and all these at the level of directorates and all these other staff members that are supposed to be paid. As we sit, Honorable Chairperson, we have not even been able to pay the staff from the traditional council. For instance, the staff of Amakosi the administrators that administers the traditional councils, as well as the security, the cleaning staff, and all other staff that administers our traditional council offices. They are not paid as we talk. And yet we are now talking about many other staff members that need to be paid, honorable members. So in this regard, Chair, we do not believe that this bill, our mind have been applied properly in terms of this bill having been costed and this bill having been practical in terms of us realizing what we are talking about. But also, honorable members, we cannot say people have got a choice of going to courts. We know that our people cannot afford to go to the High Court when they are not satisfied. When we are asking ourselves as to why should you create two systems where people, when they are not satisfied, they must go to another court. And those are all the issues, Honorable Chair, that we are not satisfied with. Thank you.
Thank you very much. Any other declaration? None. We shall therefore proceed to voting on the question. And the question is that the bill be agreed to. And when called upon, the heads of delegation must indicate whether they vote in favor, against, or abstain. We will do so alphabetically, starting with the Eastern Cape. Eastern Cape.
Eastern Cape, yeah, Xhosa mhlali ngaphambili.
Eastern Cape, Xhosa, Free State.
Free State is in support.
Free State in support. Gauteng.
Gauteng in support.
Gauteng in support. KwaZulu-Natal.
IZulu Natal asiyiseki sihlalo, against.
We don't support. KZN doesn't support.
Natal is against. Limpopo.
Limpopo supports.
Limpopo supports. Mpumalanga.
Mpumalanga support.
Mpumalanga supports. Northern Cape.
Northern Cape supports, Honorable Chair.
Northern Cape supports. Northwest.
Northwest support, Chair.
Northwest support. Western Cape.
Western Cape does not support.
So Western Cape is against.
Correct, yeah.
Okay, thank you very much. Voting is now closed. 7 out of 9 provinces have voted in favor. I therefore declare the bill agreed to in terms of section 65 of the Constitution. Thank you very much. We'll then move on to the fourth order on the order paper.
Thank you.
The fourth order, recognition of customary marriages amendment bill, B12B-2017, and report of Select Committee on Security and Justice thereon. I now call upon Honorable Sheikh to present the committee report. Honorable Sheikh.
Thank you, Honorable Chairperson. The Recognition of Customary Marriages Amendment Bill was referred to the Select Committee on Security and Justice on the 9th of June 2020. The committee has agreed to the bill with amendments. Honorable Chairperson, the Recognition of Customary Marriages Amendment Bill aims to amend the Recognition of Customary Marriages Act 1998 by further regulating the proprietary consequences of customary marriages entered into before the commencement of the RCMA in order to bring the provisions of the Act in line with the judgments of the Constitutional Court, which the Court found to be constitutionally invalid because they discriminate unfairly against certain women in customary marriages. The Constitutional Court in Ramohovi and others versus the President held that Section 7, subsection 1 of the RCMA inconsistent with the Constitution because it discriminates unfairly against women in polygamous customary marriages which were entered into before the commencement of the Act on the basis of gender, race, and ethnic or social origin. Currently, Section 7, subsection 1 of the RCMA provides that the proprietary consequences of a customary marriage entered into before the commencement of the Act continues to be governed by customary law. This in effect means that such wives have no right of ownership and control of marital property, and that the right of ownership and control of marital property is the sole preserve of the husband. This was found to be the case particularly in vendor customary law. The Constitutional Court suspended the declaration of constitutional invalidity for 24 months to afford Parliament an opportunity to enact remedial legislation, that is before the 30th of November 2019. However, the suspension of the declaration of invalidity was accompanied by an order for interim relief that would continue to apply should Parliament fail to correct the defect by the time limit set. Honourable Chair, Clause 2 of the Bill amends Section 7, subsection 2 of the RCMA in line with the judgment in Gumede versus the President of the Republic of South Africa, in which Section 7, Section 2 was declared constitutionally invalid because the section made only customary marriages entered to after the commencement of the RCMA Act, where a spouse is not a partner to any other existing customary marriage to be a marriage in community of property. The effect of this amendment is that all customary marriages, whether entered into after or before the commencement of the RCMA, will be marriages in community of property and of profit and loss unless the spouses decide to exclude that by means of an antenuptial contract. Honourable Chair, in terms of the procedure, the Department of Justice and Constitutional Development briefed the committee on the 23rd of June 2020. Provincial legislatures conducted the public participation process between September and November 2020. And due to the COVID-19 pandemic and national restrictions on public gatherings, provinces were afforded additional time to conduct public participation. Honourable Chair, the committee received all 9 negotiating mandates. 8 provinces were in favour of the bill. On the 10th of November, the committee considered the negotiating mandates and the responses by the Department of Justice and Constitutional Development to the mandates. During the committee's deliberation, a concern was raised to the effect that the bill fails to define the forms of property ownership at customary law, such as marital property, house property, family property, and personal property. The committee, however, agreed with the department's explanation that the insertion of definitions of these terms in the bill would require in-depth research, as well as extensive consultation with the relevant stakeholders, so as to avoid unintended consequences to the detriment of women in customary marriages and whom the bill aims to protect. The committee noted that the South African Law Reform Commission with the Department of Home Affairs is reviewing the South African marriage regime, and that this process is better placed to investigate the definitions of forms of property ownership at customary law, and therefore requests that the ministry bring the matter to the attention of the Commission for investigation. Further, the committee recommended that many of the general comments received from provinces in relation to marriages should also be referred to the Department of Home Affairs for their consideration and action. The committee further encouraged the Department of Justice and Constitutional Development to heed the call made by provinces for extensive public education on the bill to ensure that all persons understood the amendments made by the Recognition of Customary Marriages Act. Honourable Chair, the Select Committee met on the 18th of November 2020 and adopted the A-list of proposed amendments. Amendments were made to 2 clauses of the bill. Clause 1 was amended to revise the definition of traditional leader so as to align it with the definition as contained in the Traditional and Cohesion Leadership Act number 3 of 2019 once the Act has commenced. Honourable Chair, Clause 4 was amended as well to reflect that the bill is now a 2020 bill as opposed to a 2019 bill. Chairperson, the Select Committee met on the 25th of November to consider final mandates. At this meeting, the committee had received only 8 final mandates, 7 in favour of the bill with 1 province not in favour of the bill. The committee did not receive a final mandate from the Northwest at the time of the meeting. However, the final mandate from the Northwest in favour of the bill was received after the decision of the committee. The committee report was duly adopted on the 26th of November 2020, as the committee was satisfied with the proposed amendments and with the content of the bill. And the committee is of the view that the bill will go a long way in ensuring gender equity and for the equitable distribution of assets for women in customary marriages. The committee is mindful that the Department of Home Affairs is embarking on a process to develop a new marriage policy that is inclusive and will embrace equality, human dignity, and non-discrimination, and recognize cultural and religious beliefs of various communities in the country. As part of this process, the committee is sure that the Department of Home Affairs will attend to the concerns in relation to marriages generally as raised by provinces in their negotiating mandates. Honorable Chairperson, the Select Committee on Security and Justice, having considered the recognition of customary marriages amendment bill B12 2019, referred to it and classified by the JTM as a section 76 bill, submits an amended bill, namely the recognition of customary marriages amendment bill B12B 2020 for the council's consideration. Thank you very much, Chairperson.
Thank you very much, Honorable Shaik. We will therefore proceed, having concluded the debate, by moving on. So I shall now allow the provinces an opportunity to make their declarations or vote in terms of Rule 71 if they so wish. And just a reminder, maximum of 3 minutes per declaration. Any province wishing to make a declaration?
Honorable Chairperson.
That was Scotland.
Thank you. Honorable Chairperson, the Western Cape holds the view that while the constitutional invalidity is addressed on a technical level, the bill fails to ensure that wives in polygamous marriages will henceforth be able to exercise the rights afforded to them in practice. The bill fails to define the term marital property, house property, and family property, therefore creating a loophole through which traditional leaders and husbands in polygamous marriages may determine property that rightfully should fall within these categories to be designated to fall within the sole control of the husband and so-called personal property. The Department of Justice and the ANC did not want to accept proposed definitions of these terms during public and committee hearings in both houses, on the basis that it may lead to unintended consequences, examples of which could not be supplied. We are of the view that to support this bill would mean to fail women living according to customary practices and who are still subjected to patriarchy and the refusal of their basic rights. The Western Cape, therefore, cannot support this bill.
Thank you very much, Honorable Skakne. Any other declaration? Since there's none, and that being the case, we'll now proceed to voting on the question. And the question is that the bill be agreed to. When called upon, head of delegations must indicate that they vote in favor, against, or abstain. And will do so in alphabetical order. Now we move on to voting. Eastern Cape.
Eastern Cape Council report.
Eastern Cape Council report. Free State.
Free State is in favor of the report.
Free State in favor of the report. Gauteng.
Gauteng in support.
Gauteng in support. KwaZulu Natal.
KwaZulu Natal iyayiseka sihlalo report.
Natal iyayiseka. Limpopo.
Limpopo supports.
Limpopo supports. Mpumalanga.
Mpumalanga support, Chairperson.
Mpumalanga supports. Northern Cape.
Northern Cape supports, Honorable Chair.
Northern Cape supports. Northwest.
Northwest support, Chair.
Northwest supports. Western Cape.
Chairperson, the Western Cape vote against the bill. I hear that some of the provinces said they support the report, Do they support the bill or do they support the report?
No, that's what the duty indicates how we are voting. So Western Cape against the report. Voting now is now closed. And in terms of the results, here they come. The results as follows. 8 provinces have voted in favor. I therefore declare the bill agreed to in terms of Section 65 of the Constitution. Thank you very much. The next order is the 5th order. And the 5th order is a report of Select Committee on Petitions and Executive Undertakings. Announcement tables and committee reports in November 2020, page 150. Lisa Well petition hearing held on the 23rd of September 2020 and 30 September 2020 as adopted on 18 November 2020. I now call on Honorable Z.V. Ncita, Chairperson of the Select Committee, to present the committee report. Honorable Ncita.
Thank you very much, Chairperson. Good morning to the leadership of the NCOP, my colleagues, and those that are listening at home. Chairperson, we present to you a Lisawela petition, which we received on the 30th of October, and then it was referred to the committee by the Chairperson of the National Council of Provinces for consideration and reports. The petitioner, Mr. Michael Landsman, who has been filed a petition in his capacity as a director of Lisaweli, a local NGO on behalf of the residents of Winberg and Mfakelekela Township of the Free State Province against Masilonyana Local Municipality. The petitioner seeks the intervention of the NCOP in relation to the following: the evaluation of the jobs of the entire municipality, especially the managerial position and the mayorship. The dams to be cleaned and adequately maintained. The landfill site is to be operate within the illegal dumping. Prepaid electricity meters should be installed in order to enable the community to buy prepaid electricity directly from Eskom. In terms of administration, the petitioner required that minutes of all meetings within the municipal manager be provided to the petitioner. Sport ground to be fixed and be maintained. Maintenance of the road infrastructure, town hall to be fenced off, initiation of forensic audit on all grants received by the municipality from 2014 until 2019. Initiate of a forensic audit into insurance claim made by the municipality. The committee held held 2 meetings, Honorable Chair, on the 23rd of September 2020 and on the 30th of September 2020. The committee made the following observation and key findings in relation to the various submissions made on the subject matter of the petition. The petition indicates that since 2016, the municipality had not submitted the annual financial statements to the Auditor General of South Africa. As a result of this, of its poor financial management, the municipality was placed under administration by the provincial government in 2018. The committee noted that the request financial recovery plan of the municipality, the closed-up report the preliminary forensic report, and the number of Hawks cases about wrongful payments of monies meant for ESCOM still yet to be finalized. The municipality had appealed before the Standing Committee of Public Accounts, SCOPA, on 17 September 2019, where most of these were discussed. There were still capacity challenges in the municipality. It noted that although it had not submitted its annual financial statements yet, it received its local government equitable share. SALGA with COGTA and the EXCO had set up a committee to assist municipality regarding the intervention. Its capacity to collect revenue and had been impacted by the struggle to recruit people into strategic position, which impeded the ability of the municipality to deliver its mandate. SALGA, together with COGTA, was assisting the municipality as it was fully compliant with the Spatial Planning and Land Management Act. SALGA had done capacity building training on the Municipal Accounts Committee, MPEC, and was helping the municipality to fulfill the Section 57 appointment to vacant leadership position to strengthen the oversight. SALGA submitted that the municipality is currently categorized by National Treasury as experiencing technical insolvents in higher when compared to current assets, and it owes ESCOM amount more than 80 million by the end of 2020 June. And it further owes a number of creditors, including SARS, AXA, etc. Collection levels are too low. Valuation rolls is missing key customers. ESCOM was not honoring the 1994 agreement, which states that where ESCOM supplies electricity in municipal space, it had to pay servitude fees and royalties to the municipality. The committee made the following recommendations. The Marceloniana local municipality to furnish the House with a close-up report indicating that they are no longer under Section 139. In noting the dire financial administration constraint experienced by the Marceloniana municipality, the committee requested the following. The Marceloniana municipality to provide the House with a forensic preliminary report relating to the financial status of the municipality. The Marceloniana municipality to provide the House with a detailed financial recovery plan. And again, to provide the House with a detail on filling strategic position that would enable effective management and increase the oversight role. The Marceloniana municipality to provide the House with the update on engagement with ESCOM with a view to setting the debt owed to ESCOM. The last one is the committee refer the matters in the petition to the select committee on public accounts for further investigation into their financial position. Thank you very much, Chair. I submit the report.
Thank you very much, Honorable Nita. I will now put the question. The question is that the report be adopted. Before we proceed to voting, I shall now allow provinces the opportunity to make their declaration of vote in terms of Rule 71. That is, if they so wish. Maximum time allocated for this purpose is 3 minutes. So it's 3 minutes per declaration. Any province wishing to make a declaration? None. We'll therefore proceed to voting on the question And the question is that the report be adopted. I now call upon the provinces to cast their votes. And when called upon to do so, heads of delegations must indicate whether they vote in favor, against, or abstain. We'll start in the Eastern Cape. We'll do so alphabetical. Start with the Eastern Cape. Eastern Cape.
Eastern Cape, I cast a report.
Eastern Cape, I cast a report. Free State.
Free State adopt the report.
Free State supports the report. Gauteng.
Gauteng in favor.
Gauteng in favor. KwaZulu Natal.
KwaZulu Natal, iyayeseka.
KwaZulu Natal iyayeseka. Limpopo.
Limpopo supports.
Limpopo supports. Mpumalanga.
Mpumalanga support, Chair.
Mpumalanga supports. Northern Cape.
Northern Cape in favor, Chair.
Northern Cape in favor. Northwest.
On stem some, Chair.
Northwest stem some. Western Cape.
Western Cape support.
Western Cape supports. Having closed the reports and having examined the voting, 9 provinces have voted in favor. I therefore declare the report adopted in terms of Section 65 of the Constitution. Thank you very much. We'll proceed to the 6th order. 6th order, report of Joint Standing Committee on Intelligence. Activities of committee after 5 months of establishment as stipulated in the Intelligence Services Oversight Act, Act number 40 of 1994, dated 27th October 2020. I now call upon the Honorable Nita, member of the Joint Standing Committee, to present the committee report. Honorable Nita.
Thank you very much, Chair. As you have indicated that we will be presenting the report of the Joint Standing Committee on Intelligence on the activities of the committee after the 5 months of establishment, as stipulated in the Intelligence Services Oversight Act number 40 of 1994, dated 27 October 2020. Chairperson, the Joint Standing Committee on Intelligence is established in terms of the Intelligence Act, as I have indicated, to perform the oversight functions set out in the Act. During 6th Parliament, the committee was constituted on the 30th of October 2019 after the process of undergoing vetting to top secret security clearance, which is a statutory requirement. Having been nominated by their respective political parties, the Minister of JSCI are appointed by the President in consultation with the Speaker of the National Assembly and the Chairperson of the National Council of Provinces. In terms of Section 2(4) of the Act, the President, in consultation with the Speaker of the National Assembly and the Chairperson of the National Council of Provinces, is empowered to appoint a member, excluding those appointed to the committee in terms of Section 2(3) as the Chairperson of the committee. The purpose of the report: the Constitution of the Republic of South Africa of 1996 recognized that Parliament has an important role to play in overseeing government departments and its public activities. The Act ensures that JSCI performs the oversight function as set out in the Section 3 in relation to the intelligence and counterintelligence function of the services, which include administration, financial management, and expenditure of services. The purpose of this emanated from Section 6(1) of the Act, which states that The committee shall, within the 5 months of its appointment and thereafter within 2 months after 31st March in each year, table in Parliament a report on activities of the committee during the proceedings of the year, together with the findings made in it and the recommendation it deems appropriate, and provide the copy thereof to the Parliament and the minister responsible for each service. Appointment of the JSCI. It is pertinent to note that the legal processes of finalizing the appointment of the committee were delayed for various reasons. Consequently, the committee was appointed in terms of the Act on the 30th of October 2019, as I indicated. The first meeting of the committee took place on the 13th November 2019, following the swearing in of members. The members of the committee must take an oath of affirmation of secrecy before commencing their function as prescribed by the Act. The composition of the committee. The committee consists of members of Parliament appointed on the basis of proportional representative determined according to the formulation set out in the Act. The chairperson is appointed separately in terms of Section 2(4) of the Act. Accordingly, the following seats were allocated to various political parties following the 2019 elections. African National Congress, 8 seats. Democratic Alliance, 3 seats. Economic Freedom Fighters, 1 seat. Members of the committee are as follows. Chairperson, Mr. Make, the ANC member, Ms. LCBB, NCOP member, Ms. MC Dikhale, ANC, NA, ANC, Ms. D.A. Dlakude, NA, ANC, and Ms. N.L. Armans, NA, ANC, Mr. G. Magwanishe, NAANC, Ms. J.M. Mufukeng, NAANC, Mr. K. M.K. Moimang, NCOP ANC, Ms. Z. Vingita, ANC NCOP, Dr. M.M. Gondwe, NADA, Ms. D. Kolabanat, NADA, Ms. C. Skafni, I'm sorry for that, NCOPDA, Dr. M.Q. Rosie, NAEFF. Those are the members of the committee. Orientation of members. The Act provides for the establishment of JCSI for performing oversight function relating to intelligence, counterintelligence, function of intelligence services, and report thereof on the Parliament. After the committee has been established following awarding of top secrecy clearance certificate, members must undergo intensive, as I've indicated, orientation in the field of intelligence. Section 5 Act clearance stipulates that the committee shall conduct its function in a manner consistent with the potential of the national security. Furthermore, a person shall disclose any intelligence information or document, the publication of which is restricted by the law and which is obtained by the person in the performance of his or her functions in terms of this Act, in order to adhere to the Act intensive induction and training in provided to members. For the 6th Parliament, orientation for the members took place on the 18th to 22 November 2019. It enables members to understand the nature and the environment, an environment coupled with the complexity of the fourth industrial revolution and its implication to intelligence and national security, how to handle secrecy and responding to public queries on sensitive issues related matters. The orientation prepared the committee to function optimally to ensure that safety and security of information. More importantly, the newly established committee was briefed on the functioning and roles of the services and their entities. Additionally, the committee received an overview of the pertinent issues within the intelligence services, namely the State Security Agency, South African Police Crime Intelligence, and Defense Intelligence of South African National Defence Force. The Office of the Inspector General Intelligence also inducted members in order for them to understand the functioning of the Inspector General of its intelligence as stipulated in the Section 77 of the Act. On the 19th November 2019, the committee interacted with the SSA. It was welcomed by the Acting Director General of State Security and senior management. The presentation touched on its current status, challenges, and recommendation on improving the agency. The acting DG clarified the illegalities of the establishment of the SSA, which came into existence in 2009 after
Left, Honorable Nita, 1 minute left.
Thanks, Chair. Proclamation of 2019 by former President Jacob Zuma, several entities were amalgamated. These including the National Intelligence Agency, functioning of the intelligence with the mandate gathering intelligence and counterintelligence. South African services, which gathered intelligence inside the borders. This was a major problem, Chairperson, which committee have to deal with it. We are still in consultation with the ministry to deal with the matter. Thank you very much, Chair. I therefore submit the report.
Thank you very much, Honorable Nita. The question is that the report be adopted. I put the question being that the report be adopted. But before we proceed to voting, I shall allow provinces the opportunity to make their declaration of vote in terms of Rule 71, if they so wish. Maximum 3 minutes per declaration as a reminder. Any province wishing to make a declaration?
No.
No. And there being no declaration, we shall now proceed to voting on the question. And the question is that the report be adopted. I now call upon the provinces to cast their votes. And when called upon, head of delegation must indicate whether they vote in favor, against, or abstain. We'll do so in alphabetical order, starting with the Eastern Cape. Eastern Cape.
Eastern Cape, I am getting a report.
Report. Free State.
Free State support.
Free State supports. Gauteng.
Gauteng needs support.
Gauteng supports the report. KwaZulu Natal.
KwaZulu Natal, yes,
SSN supports, Chairperson.
Limpopo supports.
Limpopo supports. Thank you very much. Mpumalanga. Mpumalanga. Mpumalanga.
Mpumalanga support.
Support the report. Northern Cape. Support the report. Thank you very much. Then we'll go to Northwest.
Northwest support, Chair. Northwest Sam.
Support the report. Thank you very much. Western Cape.
Western Cape support.
Western Cape supports the report. Now, if you look at the votes there, you'll see that 9 provinces have voted in favor of the report. I therefore declare the report adopted in terms of Section 65 of the Constitution. Thank you very much. Honorable delegates, I would like to take this opportunity to thank the special delegates for availing themselves and to thank everyone who's been a participant in this important sitting of the National Council of Provinces. That, honorable members, concludes the business of the day. The House is now adjourned.
Oh, Chairman, you look good today.
Thank you very much.
Special delegate. Siyathokoza baba. MEC Ube. Sharp.
Chief Whip.
Bravo. Thank you.
Chief Whip.
Traditional court bill. Thank you very much.